Hi, everyone. Welcome. We're just going to wait until 2:05 so that people can come in, and then we'll start today's discussion. Thanks. And we'll give it maybe a minute more, and then we can get started. All right, well, we can get started. Hi, my name is Brian Chen. I'm a staff attorney at the National Employment Law Project, and I'm joined by my colleague Becky Smith, who leads our team on work structures. And we'll be moderating today's panel entitled Winning Contract Workers Access to Unemployment Insurance. So as most people on this webinar probably know, independent contractors, people who are legitimately self-employed, usually aren't entitled to state unemployment insurance. And the problem is that many workers, particularly in the casual or gig economy, are misclassified as contractors, but really should be entitled to unemployment insurance because they meet the state's definition of employee. And in some notable cases, courts have found that misclassified workers are eligible for regular state UI. And today we have two great panelists with extensive experience in this area. So I'm very pleased to introduce them. We have Julia Simon-Mishel, supervising attorney with the Unemployment Compensation Unit at Philadelphia Legal Assistance. And we also have Zubin Soleimany, staff attorney and general counsel with the New York Taxi Workers Alliance. And both of them have brought and won cases recently that established that certain misclassified workers, specifically app-based drivers, are entitled to receive regular state unemployment. So we're going to talk about those cases today. We're going to talk about the facts, the law, the holdings. And the point really is not simply to celebrate these cases, although they are worth celebrating, but really to encourage other lawyers to bring these kinds of cases across the country and really to brainstorm effective ways that litigation can advance workers' access to unemployment insurance. We will be recording this webinar and we're going to be sharing it once it's over. And we'll also share the slides that are during the presentation. So if you need to take notes on them, we'll be sharing those notes after the presentation. We will be doing question and answer. So there is a Q&A box. You'll see a Q&A box at the bottom of your screen. Please use that as any questions come up in your minds, and we will try to ask them as we get them. And we're also going to leave some time at the end of our hour for any remaining questions that you may have, so that we can try to get everyone's questions. And with that, I am going to kick it to Julia, who has prepared a presentation on a recent case at the Pennsylvania Supreme Court.
Great, thanks Brian, and thanks for having me. Excited to talk to you guys today about our recent win in Lohman versus the Unemployment Compensation Board of Review. I'm gonna go ahead and get the PowerPoint up there. So Lohman is a case in the unemployment compensation context that began in 2015 when I first met my client, Donald Lohman, who came to me when he was appealing a determination that had disqualified him from unemployment benefits in Pennsylvania, and we prepared for the hearing. So before I get into kind of specifics about the case, back then and still now, what we were seeing in our office at Philadelphia Legal Assistance, which has the highest number of unemployment compensation cases in the state of Pennsylvania, is a lot of clients who were walking in the door who had been deactivated from driving for companies like Uber and Lyft and were trying to qualify for benefits and were not able to because their wages were not showing up in their notice of financial determination because they were considered wages not earned in employment. We were also seeing a lot of workers who were disqualified from benefits they had already qualified for because they started to drive for Uber and Lyft after qualifying for those benefits. In those cases, they were being disqualified under a provision that refers to self-employment. And in essence, in all of those cases, we were seeing what boiled down to a total presumption that these workers were self-employed. We almost never saw a case where they were initially found to not be self-employed. We saw a lot of those cases also come to us after they had been to a hearing pro se, and we saw that typically Uber and Lyft were appearing at those hearings by telephone with counsel. So they were actively involved in all of these unemployment hearings, kind of nonstop. And on a broader scale, we were seeing at that time that there really wasn't any progress on the issue of the classification of these workers in the wage and hour context, due primarily to arbitration clauses and the inability of attorneys and plaintiffs to get to the merits of the issue. And one of the things I think as many of the people on this call know is that arbitration clauses don't apply to areas of administrative law like unemployment benefits. And so we knew that an unemployment case would allow us to get to the real merits, the question of the classification of our clients as employees or independent contractors. So how did we pick the case? Well, I was looking primarily for that second area, a self-employment disqualification case. And that's because I thought bringing it up at that time to our Commonwealth Court, which had a more conservative bent, and to our Supreme Court, which at that time in 2015 looked very different than the court that heard the case in 2019, I thought that having someone who was disqualified from benefits they had already qualified for was a much more sympathetic avenue to pursue this issue. And it didn't imply immediately that companies would then have to start paying unemployment taxes, which I thought would be helpful with the judges. And I had this kind of choice because typically the test that is used is the same in both areas, both for initial qualification and then also in the situation where someone's disqualified because they start engaging in work for Uber and Lyft after receiving unemployment benefits. Mr. Lohman himself had great facts. He had been driving after losing a full-time job in a different field and had really thought a lot about these issues. He's an incredibly articulate and intelligent man. And we worked very closely together to try to retrieve every single email and text message that he had from Uber over the past, at that point, it had only been 4 months or so that he had been driving. And importantly, in a case like this, Mr. Lohman was and is a fighter who was in it for the principle of the matter. And that's really important because in an unemployment case like this, we expected to lose all the way. I did not expect to win, or I hope to win at a much later point in the process, and I'll get to that in a second.
And Julia, we have a question here. Did Mr. Lohman proactively reach out to your office, or did you go out and find him somehow?
So our office is a legal services office. So we have lots and lots of low-wage workers walking in the door and coming to us for representation on employment issues. And Mr. Lohman came through our intake. And so I'm in charge of all intake assignments. And when I saw his case, I took that one myself and worked it up. So the self-employment disqualification says that somebody is disqualified for any week that they are engaged in self-employment. But what does that really mean? Well, it's not defined anywhere in the law. And the ALJs and the appellate court had used a variety of different tests to evaluate what is self-employment. But most often they used the test when there was a third party or a putative employer involved. And that is the test for employment under the Pennsylvania Unemployment Compensation Law. In essence, if you did not work in employment, you were therefore self-employed. And the test in Pennsylvania for employment in our unemployment compensation law is pretty much the AC test. For those who are familiar with ABC, it involves the control prong and the independently established business prong. So as I said, I never thought I was going to win this case for many, many, many stages. And we built the case like that. Again, Mr. Lohman was aware that we were in it for the long haul. And I also really focused early on what I could do to make sure Uber was participating along the way, because I knew that this case would only have impact if Uber was an active participant and couldn't just push this to the side as something that happened without them in the room. And so we knew again that they were going to participate with some sort of counsel, and in preparation of this telephone hearing with me and my client who would appear in person and counsel for Uber by telephone, we submitted 23 different exhibits, which is a lot for an unemployment hearing. And as soon as the referee reviewed the exhibits at the beginning of the call, Uber's counsel immediately requested a continuance, and they showed up at the next hearing in person with counsel and their own witness, which led to a really in-depth case, an in-depth hearing with a 44-page transcript. So we really had a pretty full record, especially for, again, an unemployment case. So as expected, we lost at the referee hearing. We lost at the Board of Review level. And then we were granted reconsideration at the Board of Review level, which we were very excited about, only to lose again on reconsideration. And so then I appealed to the Commonwealth Court, and lo and behold, Uber intervened in the case, because I think as hopefully some of you who are familiar with unemployment cases know, when you appeal a decision at that stage in the process, the two parties are actually the government that's defending its decision versus us as the appellant contesting the government's decision, and Uber as the other party who had been involved in the case has a right to intervene. And unsurprisingly, they did. In that case, both Uber and Mr. Lohman and I argued the case under that AC test, really focused on the control prong and the independently established business prong. Interestingly enough, the government, the Unemployment Compensation Board of Review, did not actually participate in the case at the Commonwealth Court. They rested on Uber's brief and didn't participate in oral argument. And I think, and became clear later on, it was because they were pretty, I think, torn about what they actually thought of the underlying issue, and didn't really want to be involved on either side when it came to what was happening with Uber and Lyft and the gig economy employers. So surprise, surprise, we actually ended up winning at the Commonwealth Court. Again, we didn't expect that, although we had a really fascinating oral argument with the en banc court, and I can work to see if there's a way to share that video with anyone, because I actually think it's the most interesting argument that's happened in this case, where you can really see judges who I never would have thought would have sided with us really thinking through the issues that were before them, and you can kind of see them realize as the argument went on that there was something really fishy about Uber's business practices. So the court ruled in our favor, 7-0, that my client was not self-employed. And also, I don't think I mentioned this earlier, but just to be clear, Mr. Lohman was an Uber X driver, so he was using his personal vehicle. But instead of using that AC test, the court came up with kind of a new test that worked off of one of these other positive steps tests they had that found that my client was not self-employed because his actions did not establish he intended to start a business. And it was a really subjective standard that in some ways was really good when it came into practice. We saw pretty much all of our clients get granted benefits during that time, but we had some real concerns at some point that without objective facts, at some point the government would just start discrediting our clients' testimony. It would be really hard for them to win these cases. At that point, the board re-engaged with the case and actually filed a petition to the Pennsylvania Supreme Court because they didn't like the test that the court had used, and they wanted them to use the AC test because that historically would have been the test in this situation. And so in a slightly unusual move, we did not submit a no contest letter, or sorry, no answer letter to the appeal, and we also didn't file an opposition. We filed a petition that agreed with the Commonwealth Court's outcome, but tried to give the Pennsylvania Supreme Court a little bit of the context of how important this case could be if they took it, and really show that the underlying evidence in the record was going to give them the opportunity to rule on the gig economy in a way they wouldn't otherwise get. And so it was a bit of a risk, one that my client was fully aware of, because again, we had one below. But the Pennsylvania Supreme Court accepted the case. We argued it last fall, and lo and behold, they gave us the broadest possible decision we could have gotten, finding that indeed Mr. Lohman was working in employment, making him an employee under Pennsylvania unemployment compensation law. Now, to be clear, this case took an interesting turn when we went to the Supreme Court because the primary issue was what the test should be. And I actually took a slightly different approach. While I liked the AC test, I looked back at the history of self-employment and the law, and it really seemed like self-employment was based around people who owned and controlled their own business. And I actually thought if we could get that test back in place, that it would really help a lot of our clients, because I think that was an even easier standard for them to prove they did not own and control the business, and it wasn't going to be as fact intensive as the AC test when they would have to go by themselves to contest these cases in individualized hearings. So what that allowed me to do is that in my briefing, I was able to lay out all the reasons why Mr. Lohman does not own and control his business, which kind of turned the second prong of the AC test on its head. And I actually think really helped the justices see and understand why Mr. Lohman himself was not free from control and direction of Uber, and certainly was not an independent business person. Ultimately, they did decide that the AC test was the appropriate test, and did something rather unusual for the lawyers on the call. In order for somebody to be not disqualified under the self-employment provision, the court only had to find that one of the prongs wasn't met. So they either had to find that he was free from control and direction, or that he was either that he was not free from control and direction, or that he was not engaged in independent business. But the court ruled on both issues, which again is unusual because courts don't like to rule on things they don't have to, and really spoke, I think, to a desire for the court to really put its stamp on this question. So they found both that Uber controlled and directed the performance of Mr. Lohman's services, and that he was not engaged in an independently established business. And under the control prong, which people had been telling me since the beginning of this litigation, well, first of all, people have been telling me since the beginning of this litigation there was no way I was ever going to win this case. And especially they said that there was no way you're going to win under the control prong. And under the control prong, we really got a huge win. And the court really focused on the fact that there was an application process. Importantly, that Mr. Lohman could not have anyone substitute and provide services on his behalf. And really that Uber did monitor, review, and supervise his performance, control the pay structure, and provided the tools and equipment. And so when I say tools and equipment, I thought one of the most interesting parts of this decision was they really focused on the use of the app, right? A lot of times in the gig economy, we hear, oh, well, they use their own car, they use their own cleaning supplies, things like that. But the court really recognized that none of this was possible without Uber's app. And that was really a huge factor in this case. They also recognized that Uber generated all of the leads, determined the fares, and the percentage that my client could collect. And just to put this in perspective for a second, we focused heavily in our briefing on the contract. That was really the main piece of evidence. Everything else was emails from Uber, pay statements, text messages. Like I said, we had a really full record, but I pretty much went through the contract and just took pieces out of it that seemed to me to support the fact that my client was not free from control and direction. And that's pretty much exactly what the court followed in its decision. You'll see, if you look at the decision, that every 2 lines they're citing to a provision of the contract to support their decision and support the argument that we made. And they really did recognize that Uber operates in a different virtual world from other companies, and that their evaluation of the facts had to follow that, which I thought was really important and will really have an impact on other cases. So some main takeaways, and then I'm going to wrap up and we can get to some of the other impacts of the case in Q&A. But the most important, first of all, just to clarify, this was one Uber X driver. It's not a class action. It's an appellate decision in a direct appeal from an agency decision. And so it technically only applies to Mr. Lohman. However, the key in this case is that the focus in the decision was not on Mr. Lohman at all. It very much it almost had nothing to do whatsoever with his individual actions or facts. It was entirely on what Uber did, what Uber said, and what was written in Uber's agreement. And so it would be really hard for the agency to come to any different decision with any other driver in a case like this. And the second thing is that because it was in the self-employment context, right, it doesn't mean that a driver would apply for benefits and automatically be granted them based on driving for Uber or driving for Lyft. And in fact, that would never happen in a state like Pennsylvania unless the agency assessed taxes on Uber and Lyft, which is what I hope one of the next steps will be. If a driver applies for benefits now, they will have to contest their classification at the forefront. But luckily, they will be using the same exact test used here and the same exact facts. And so we think in many ways it's a one-to-one and it's going to really impact drivers on that side of it. So quickly, again, they focused on the relationship. They focused on facts that exist in the relationship between Uber and my client that exist in similar relationships with other platform businesses. And again, the focus on, for instance, the app was really important. They recognized, again, that monitoring and supervision look different in the virtual world in which Uber operates. And one of the things here is that Uber and a lot of other businesses have said, we don't have rules, we don't have training, we just have guidance and recommendations in our emails and things like that. And the court called bullshit on that, and they said, no, like this is supervision. In the amount of emails you send, what they include, it is supervision. And what we did in our case, which I hadn't seen anywhere else at the time, is we focused also heavily on the GPS aspect of this, in that Uber, the core of its product could only work if it GPS tracked our clients, and they say that in their contract. And so in essence, they're getting live updates and monitoring of my client every time he's on the app and every time he's driving. And then finally, they rejected Uber's argument, which again, a lot of these companies have made, that the law has to consider what he could do, my client could do. He could have built his own business. He could have expanded. Just because he's not a good business person, doesn't make him working in employment. And the court really slammed that down. It's really about what the current situation is, not this idea of how somebody could possibly expand their work in the future. And then finally, and I think that really cuts to the core of a lot of questions in the misclassification context, the court again said, we know that drivers have flexibility and they can choose their own hours, and that is, that's a little odd in the context of finding them to work in employment, but they really focus on the fact that just because the business model does not require regularly scheduled work hours does not mean that it's an automatic independent contractor relationship. And I think that's a really important quote, because oftentimes that flexibility is what is used to define the relationship and is at the forefront of these conversations. So with that, I know I'm a couple minutes over time. I'm gonna give the screen back and we'll move over to Zubin, I believe.
Well, we'll hold here for just a bit to see if there are any questions, and please use the Q&A function to submit them. I mean, one thing that came to mind, Julia, you said that you tried to focus as much on the contract, that agreement with Uber, and you tried to take pieces out of it that kind of support the opposite proposition, that they're not free from control. Can you talk about some of those provisions that really stood out to you when you were looking at that contract?
Yeah, so, they talk about and just to be clear, I think most people are familiar, Uber has changed its contract over the years, kind of like bits and pieces when they lose things here or there, but the main substance has remained the same, in part because it's their business model, and so they can't change certain aspects of it. And so, reading it, if anyone saw me and I lifted it up at the Commonwealth Court hearing, it's like penciled and highlighted throughout, because there's so much of it, just things about how, you can't share the app with anyone. You can't have anyone sign it under your name. If Uber doesn't approve the car, you can't use it. And actually, we also had the witness for Uber that confirmed a lot of this. There was everything about deactivation and what could lead to deactivation, but the fact that they didn't actually, at least at that time, give you what the number was that could get you deactivated. And then importantly, that, like I said, the GPS, which they came back and argued, consistently, the GPS had nothing to do with his work. It's for other services, blah, 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 blah. But there's no way that Uber does its work without that. They have to know where my client is, because they have to be able to pair him with someone else in, of course, an algorithm that's secret, that nobody knows and nobody has any control over, in terms of who gets assigned the next ride. And so all of that, if you read the contract closely, is really in there. It's just written in funny terms that they're trying to hide what they're really doing. But when you call them out with it and you actually cite to it, I think it's a really strong argument to use their own words against them.
We had a couple of questions, and I think some of them I want to wait until after Zubin has finished, because they are really to both panelists, and maybe even a couple for Brian. But here's a question for you, Julia. Was all the tracking and monitoring taken from the contract? So did you have any sort of issues in asserting what the technology did? Any sort of issues around proprietary software?
So everything regarding the GPS was taken directly from the contract, but some of the other monitoring pieces and performance pieces were also taken by the emails that they sent. So Uber sends these emails, kind of like these weekly updates to drivers, and at least at that time, they would show you what hours you work compared to Uber's top drivers, right? And other things that showed that they were really tracking what people did on the app. And importantly, that was also where we came on the performance supervision, by the fact that Uber says, well, we don't supervise them. And I'm like, well, you give them scores, and you also control what reviews they see and what reviews they don't. And they said, well, the users give the score, but we don't know how they calculate that score. Drivers are not told how many ratings often go into that score. We don't exactly know what weighting system is used. And so again, in some ways, the lack of transparency really hurt Uber more than us having to prove exactly what they did. The fact that that my client didn't have access to that information made it really hard for them to argue he was a true independent business person.
Thanks so much, Julia. That's a really exciting win, and thanks so much for sharing that with us. Zubin, I want to turn to you. So you recently won a very exciting case called Islam v. State of New York. I want to talk in depth about that win and what it means, but I think it's important for people here to understand kind of the legal landscape in New York right now. And part of that is discussing an earlier case this year called Vega v. Postmates that you were involved in as amicus. Can you tell us about that Postmates case, what its holding was, and then so its holding and what its importance?
Sure. Yeah. If you give me the liberty, I think I might talk about the Uber case we had first, and then how that's sort of reinforced by the Postmates case. But yeah, I work at the New York Taxi Workers Alliance as a staff attorney, and we have 23,000 members. Traditionally, they had mostly been yellow cab drivers, but the last few years, about half of our membership now drives for Uber. So this has been the world that we've been living in, and have been intimately familiar with the details of working for Uber and what that looks like. So we'd also understood the legal landscape of the black car industry that Uber came into in New York. So when we got our first unemployment case, there was a guy who walked in. He had a problem with his license, his professional license, and also said, "Oh, by the way, can you look at this email I got from the DOL? I applied for unemployment, and I don't really understand it." And he had applied for unemployment 5 months previously as an Uber driver, and his case had been collecting dust for 5 months. And I said, "Oh, well, that's weird. Well, show me the email." And the email says, "It's not just you. All Uber cases are not being reviewed right now. They are under executive review, and this means the DOL is not making the decision whether this is covered employment." So another 5 months went by. 10 months they had done nothing except this executive review, which certainly doesn't mean that the executive office of the governor was holding it up. It can't possibly mean that. So we sued the governor and the state, and then the claim was immediately processed. His case got consolidated with 2 other cases of our members, and we went forward and we had a hearing on the issue of employment status, which we eventually won. I mean, the initial determination the DOL made after we sued was that he's an employee. That was affirmed by an ALJ, and that was affirmed by the appeal board, the final administrative decision in New York. None of this was really surprising to us, and we didn't think that it was a particularly risky proposition, because there are 30 years of other workers in traditional black car companies or car services working in the same conditions, consistently being found to be employees by the DOL and by the appellate courts in New York, even when they could choose their hours, even when they could simultaneously work for 2 or 3 black car bases at the same time. So there was really nothing new about this. Like Julia was saying, if anything, the technology even enhanced the level of control that we saw. So some of my favorite exhibits, and you can assume all of this is happening everywhere, is, in terms of the control that they were able to exercise, was constant GPS monitoring, not just in the contract, but we had several instances where the drivers saw that their pay had been docked because of an inefficient route, and there was an email about it, and you saw the pay record change over time. Beyond looking to the contract and what they send to drivers, Uber will lie to us, and they will not respond accurately to subpoenas. They will not lie to their investors, and they will be less likely to lie to their consumers. So if you want to see when they want to puff themselves up and talk about the incredible capabilities of their technology, they will say that in their SEC filings. They will say that in their public website posts. So when Uber's witness said, "Oh yeah, we have GPS, but we never use that to discipline people," and then there's a post on their blog that says, don't worry, guys. Don't worry, customers. We will, if we see that a driver is going too fast, we will send them an in-app message to slow down. If they were driving erratically and you file a complaint about it, we will use that GPS information to verify your complaint. Have folks ever been deactivated based on this? Quote, you bet. So there's a world of stuff out there that might not necessarily be in the subpoena response, but we have voluminous files on that stuff. So it wasn't really a surprise that we won. And we were looking for an impact that would really be broader. There, you know, right now there are about 100,000 app-based drivers just in New York City, and they would be they are the largest private sector workforce in New York. So we were hoping that this would be really impactful, and part of that was based on the structure of the law in New York, which says that when you get a decision either from an ALJ or from the appeal board, that will apply to all of their workers who are similarly employed, and the decisions themselves said that. So you know, we expected something to change after we won. The case died when Uber appealed it to the state appellate court and then dropped the appeal, writing a letter that said, you know, we don't like this case. Effectively, they say, we don't like this case. We don't like these guys because they have lawyers. We're going to appeal another case. And, you know, we'll decide. Basically, they're saying we want to claimant shop. But as to those workers, that remained on the books, the final decision of the appeal board. And so, you know, our position here, I think, was really bolstered when the Court of Appeals, the highest court in New York, decided in March that a Postmates worker was an employee for unemployment purposes. And this, you know, our case, we had 3 drivers, we had about 1,000 pages of transcript, like 30 exhibits, 45 minutes of their training videos. But this guy, Mr. Vega, he got benefits, and then he never showed up to his hearing, never testified. The record was really just a DOL rep arguing, and he still won at the Court of Appeals. So, I mean, it sends a really strong message, I think, and the Court of Appeals says this too, that, you know, the nature of control when the job is so simple, right? It doesn't really require that much. You know, the details that we had in our record and that Julie had in this context would be helpful, but just they pointed to prior cases of theirs that said, you know, you have to look at control as sort of a context-specific thing, and where there just isn't that much control to exercise because the job is so simple, you're not going to hold that against the employee. I know somebody mentions a question of what the standard is, and in New York, it is on paper. It is a much more restrictive standard. It's a very conservative. It's a very conservative articulation of the common law master servant test. And part of what we argued actually in the amicus in Postmates was that the court had sort of winnowed it down to be even more narrow than we cited some like 19th century treatise on tort law, where they had really reduced it to one factor, which is just, you know, substantial control over the results and how they're done. And even in the 19th century, they're saying you should look to whether they have an independent business or not, right? So I think that reality sunk in a bit, and there's more language now about, you know, control over the whole operation, not just the details. So you can't really tell somebody so much about how to drive somebody from, you know, 5th Avenue to 10th Avenue. And I think the court was acknowledging that reality. So for us, that really bolstered the position that, you know, it would be sort of inconceivable to see a future in which an Uber driver after Postmates could lose a future case. But the problem we faced as the pandemic hit was, you know, we had never really seen a mass unemployment event in our workforce because there are multiple companies, because there are taxis. Typically, people would be able to find other work and not become fully unemployed. But that all went out the window in March. And the problem that drivers faced, even after winning at the appeal board, was that the DOL didn't change anything about how they operated, despite having this decision and despite having state law that required them to apply it to all similarly employed workers. And so what this ends up meaning for somebody who applies is, instead of, you know, you put in your social, the DOL looks up your wage earnings and you get benefits in 2 or 3 weeks, meant that you would get a letter saying there's no record of earnings. They would send you a questionnaire, you know, about your working conditions, as though they had no idea what those conditions were like, as though they'd never seen an Uber case before. And before this was going on before the pandemic, terribly sorry. All of this work we did with the incredible cooperation of Brooklyn Legal Services, right? So I'm not just like doing this from my bedroom like I am now, working with legal services on this. And so we litigated all of this stuff together, the federal lawsuit, UI case. And we continued to represent people after winning the appeal board decision, and Uber would contest, they would schedule hearings, and then they would, they would ditch the hearings, they default, they'd never show up. Same thing, Lyft, you send Lyft a subpoena, they drop the case. Handy, same thing. So despite that, they should have been following these decisions on the books. Now, typically what that would have meant was a 3-month delay while drivers print out all their records, mail them to the DOL, hundreds of pages like of earnings reports, and they respond to questionnaires from the worker and from Uber. In what ended up happening was during the pandemic, I mean, we were looking at 3 months and they hadn't even gotten the initial denial of benefits. We were looking at God knows how long. So we filed a federal lawsuit under the when due clause of the Social Security Act, which says that benefits have to be paid, clarified by the regs, as soon as administratively feasible. And our position was, you've decided they're employees. You have to apply that across the board per your own decisions, per your own statute, and you haven't done that, nor have you sought out their records. And here, the employers, once they are employers, the significance there in terms of, well, providing the data necessary to make the determinations is they have to provide the data under the law. And they can't simply, states can't simply throw up their hands and say, well, we don't have it, so we can't do anything about it. One thing that applies nationally here is regardless of what state regs there are, the CFR here requires states to take the initiative in getting information necessary to make determinations. So whether or not there are specific state regulations that do that. So that's in it's Appendix A to 20 CFR 602 has that, and the case law that's been developed on this further says that that the state agencies can't delay making a determination once they have all the information that they need. And we believe they had that information as to employee status, and they had that information based on data because drivers had been putting in, they'd actually been asking drivers to send in 1099s, and drivers had been putting in reconsideration requests, which is when eventually when they started getting denial saying we have $0 in earnings for you, folks would send in a reconsideration request with their proof of earnings data. When we found our way into court, we were seeking a preliminary injunction that through one method or another, the state would have to pay out benefits in line with the when due provisions of the Social Security Act. So the case is ongoing, but we did win the preliminary injunction. Which the long and short of it was that the judge required there was a certain deadline by which they had to process the backlog of 40,000 cases and get folks the right amount of benefits. And then for folks who, if somebody were to apply now, they would have to be denied within 24 hours. They say you have no earnings on record, send the driver that notice within 24 hours. And then if they send in their documents, those documents would have to be processed within 2 weeks and the benefits paid according to those documents. So I mean, it's okay. For now, it's still, I think it's a little imperfect because there's still that tension between the federal regs, which require that the impetus is on the government to seek out that data, not creating this affirmative extra step for workers to get their benefits. But hopefully we will get there. I think in terms of the lessons here for other states, I mean, I think a lot of it is dependent on what the scope of the regulations and the requirements in state law. I think we were lucky enough to have these really explicit mandates of how the state's supposed to operate once they've made this decision. I also think we had the benefit of moving quickly enough on these cases back when the companies maybe hadn't thought their plans out through this sort of appeal and abandon thing that they're doing now. I think, if they had done that at the first stage of the process and never gone to hearing, the shape of New York law may have given them more wiggle room to say, well, we don't really have a decision. I mean, that was the DOL's decision was effectively, okay, you win at the Court of Appeals, so what? Every case is a new case. Let's start it all over again as though it never happened. They're basically attempting to eviscerate stare decisis in this context. So had those decisions not been on the book, it may have played out differently. I would think, though, there would still be arguments to make about, given some of the circuit case law, about not ignoring evidence that you already have in making a determination. So I don't want to go on too long. I know, Brian, you had some questions, so I'll just cut myself off right there.
Well, we have some great questions that people submitted. Maybe one we could ask you, Zubin, is that you made an equal protection claim in the litigation as well, right? Can you talk about that?
Yeah, we made an equal protection claim. The judge didn't rule on it because she decided the motion for a preliminary injunction solely based on the when due claim. But the notion there was that we believed that drivers for these app-based companies were being treated differently from any other worker when they applied for unemployment, on the notion that we had assumed that the DOL would treat folks who had a final administrative decision on the books as employees. The DOL just came back and said, no, we treat everybody that poorly. It doesn't matter. And so I don't think that eviscerates the equal protection claim, because I think the distinction is also between, the DOL is saying, even if your employer has been found to be an employee by the Court of Appeals and you apply tomorrow, you just won't, you will have to do it all over again. The distinction is between employees who work for an employer who follows the law and between employees who work for an employer who doesn't follow the law, and that would lack a rational basis. Yeah. I would hope.
Brian, before we get to other questions, I could just throw two other things out. One, I realized we didn't talk timeline in our case. The decision from the Supreme Court came out the end of July of this year. So by the time that decision came out, we had already kind of helped chauffeur as many gig workers as possible into the PUA program, where they were already kind of like doing okay. And so we have not made a move yet to try to push people back. I know there was a question about, is this only in a post-PUA world, which is the world we're looking at right now in about 3 months. So I think there'll be a lot of discussion about that at that point. And the other thing is, we had really bad law on the books, actually, the opposite of what Zubin said. We had a Supreme Court decision on the books from 2012 that involved Black car drivers that was very similar in many ways to the facts of our case, where they found that they were indeed self-employed. And really it focused on the independently established business prong, because the government hadn't even bothered contesting the control prong in that case. And so that's what we were kind of stepping into. And so we did not have a lot of good history. Just for those of you out there in other states where you don't have good history, we did not have very good history on the question of worker misclassification under the unemployment law.
So one theme that seems to be in a bunch of comments and questions is that, obviously this area of unemployment insurance is so very state specific, but, and this question is for either of you or both of you, to what degree can these cases be, I think someone said translated, so to speak, translated for advocates in other states? And what tips would you offer to translate these holdings for people in other states?
Well, so I'll take a first crack at it. I mean, I guess the last question I see from Zach is, and NELP has written extensively about this, about states preempting application of the labor laws to, they call them rideshare drivers, and what's to be done in those cases. Unfortunately, in cases like Ohio and a lot of those other states, they're just written out of the statute, and for those workers, I don't think there would be anything to do. I think those statutes are specific to rideshare drivers. The hope would be that you could translate these to other, quote unquote gig workers, maybe the handy cleaners, the Postmates, delivery, DoorDash, those sorts of those workforces before those companies get around. Now that Uber's bought Postmates, I'm sure they'll be seeking something, an extension of that exemption in Ohio. But I think more generally, I think the New York case could be really helpful because it's hard to imagine a more conservative formulation of the test. So it's not like you have a win under ABC or under Dynamex in California, and you have to take it with a grain of salt if you're going to a common law jurisdiction. But because it is a win under such an old-fashioned test and the Postmates case as well, that cites back to some of their earliest cases from 1940, the first UI cases that say, this is what we do. And it cites back to some of the broader scope of how to treat unskilled workers from the restatement. That could be helpful. The other thing is, I think like Julia was saying, the contract is a national contract. There might be different entity names, different LLCs as the company signing the contract, but the text is pretty much identical. So anything based on that, you'd pretty much be able to make similar arguments wherever you are.
And I'd say for anyone who's in a state where you're not written out of the law, like Zubin mentioned, I recommend taking the decision from our Supreme Court and just using it left, right, and center. The court really breaks down Uber's practices and rebuts a lot of their arguments. And importantly, under the control prong, which under common law tests and a lot of the other, the control prong in one way or the other is really involved in almost every state that is looking at this question of classification under at least the UI law. And so I think this really provides a roadmap for how to argue these cases in other states. And so I do think it can really be translated pretty easily in that way to these other states. And especially, I'll just point out one of the things we had argued and that the court went with is that at least in Pennsylvania, you're prohibited from driving passengers unless you have a license, right? Like it's called this is an awful term, but people called it gypsy cabs, right? Back in the day, and they prohibited that. And the only way these drivers can operate is under Uber or Lyft's license, right? And like getting a license themselves is often prohibitively expensive for people who are working this in the gig economy. And I think that exists in a lot of states as well. And so we were really able to rely on that to kind of, again, beat back against this idea that they were independently established businesses when they were driving for something like UberX.
One question that I have is that, if we know that the companies so often appeal every case, abandon the appeals, what should be a strategy to fight that practice?
I'll say, they didn't abandon ours. So in fact, they stuck their nose in it continuously to the extent that at one point the Commonwealth Court were like, why are you here? Like, why do you even care if this person gets benefits? Because you're not paying into the fund. These benefits aren't based on the fact that he worked for you. And so they just looked awful. In fact, the more they fought, I think the more they looked like an employer. And so I do think that one of the ways, and I'm now saying this on a national webinar, and who knows who's on this call, one of the ways to do this is to debate them in a way where it's not super public. Like, this was not a case that was getting a lot of attention. I think they saw this as like, oh, just a little legal services case, like no need to worry about it. And we tried to play that up throughout until the first oral argument, when I think they were rudely awakened to what we were bringing to the table. But I think that was one of the things that helped, is that they don't see this initially as a case that was going to have a large impact. And so I think they stayed involved for that reason for quite a while. And so I don't know how to necessarily duplicate that elsewhere. But there was a reason I didn't talk publicly a lot about this case for the first 4.5 years we were doing it until it was fully submitted, because I also didn't want to play up to the court how much of an impact this could have, because I didn't want to scare them off from getting involved. And so these are just different kind of strategies for how you want to litigate cases in today's kind of media, the world of our media and both online and print.
Yeah, I think this is the issue that we're basically going to be handling sort of head on as our litigation continues. In terms of how it might be addressed in other states, I think it might kind of be state specific, but I would start off by sort of wanting to know what the treatment has been, even if there aren't reported final decisions. Is there a public records request that you can do with the agency to see how the cases have come out that might not otherwise be publicly available? Can you establish that they're on notice of having knowledge of the facts of this company, and does that get you anywhere in terms of what obligations they may have under their statute or regs to move those decisions quickly? If you're experiencing the same kind of delays, if there's any state where that is happening. I know, California, New Jersey, Massachusetts are taking this seriously. As far as the other non-exempt states, I'm not sure if anybody else is encountering a similar problem, but yeah, I think, I know prior to Dynamex, California had been kind of in a state of stasis where I think there were dozens of ALJ determinations, but none of them ever got a marker as being precedential. So, nothing really changed. But I think, it's worth, if that is the strategy everywhere, I don't know, I'm not sure, it might require legislation.
And this may be our last questions given our time, but we have a great question here from Dylan. Can you talk about any advocacy efforts that happened outside of litigation that you think might have helped move this? So outside of, smart briefing and strategic decision-making, what other kinds of organizing or media efforts do you think played a role in any of this?
So I'll go first because mine is less exciting than Zubin, so I'll let him finish. So Philadelphia Legal Assistance is an LSC funded organization, and so we are somewhat limited in the organizing and advocacy efforts we can do outside of litigation. And like I said, I strategically chose to keep this case out of the media as much as I could because I didn't want to tip my hat. But I will say that we have a fantastic group of drivers in Philadelphia that has been organized by an entity called the Philly Drivers Union. They have been doing a lot of really wonderful organizing in media around these issues that I think has gotten really good attention. There was a Third Circuit case that got some attention as well that involved Uber Black drivers. And so I think that there was kind of like a percolating idea that there was an issue here that was getting a lot of attention. And of course, I think things have been happening across the country that have helped with that. But in terms of actual kind of organizing on our part, it was mostly just around making sure that we had drivers lined up to argue these issues if we needed them.
And Zubin, I believe the day you filed your suit, you had a New York Times article.
That never hurts, right? Yeah, that's my advice on what getting here. Yeah, I mean, there was a lot of media coverage, and we just did a lot of outreach to our members back in 2016, 2017, letting them know that they had those rights, right? That if they found themselves deactivated, that they would have a right to unemployment. And throughout the pandemic, we've put out, we've made ourselves constantly available to have informational guidance for folks about applying for unemployment, and that they do have that right, which I think, after years and years of propaganda from the companies that they don't have that right, it's really important to reinforce that message. And going forward, even with appealing their initial determinations right now, not being fully qualified. I do just want to close because somebody asked about PUA, and I think there's an important thing to address there, which came up in our case, was the date, like about 20 minutes before oral argument, on our motion, the DOL released PUA benefits to our members. in an apparent attempt to sort of, moot out, well, there's no irreparable harm because it's either getting some money. And the reason why that wasn't sufficient and that wasn't correct was because they gave them PUA benefits still at the self-employed rate, which PUA treats your wages differently if you're an employee. If you're an employee, you're supposed to get whatever benefit you would get under state UI. If you're considered self-employed, they look at your net income. And for folks like Uber and Lyft drivers, there's a vast difference between the gross payments from your company and your net income. So for some people, this was the difference of $300 a week. So in terms of, maybe you represent clients or you're getting calls from people who are getting PUA, and depending on how the rate is calculated in your state, there might be a lot more money available to them under traditional benefits. Our folks, after all the back payments were released from folks in the past couple of weeks, people were getting $7,000, $8,000 chunks of back benefits. The other thing is that depending on where you may be, benefits may be available for a longer time under traditional state UI than under PUA, which is set to expire. I think it's 46 weeks now. So yeah, it's I think the companies tried to push a line, emailed the drivers constantly to say we're working hard in Congress lobbying to get you benefits, but in a lot of states you may already have benefits and they may be much better than what you're getting under PUA. So I think an important point to consider if folks have questions about that.
Yeah, that's a really good point, Zubin. Well, it's 3 o'clock. I want to thank Julia and Zubin so much for joining us and sharing their expertise and talking about these 2 exciting cases. So we will be sending follow-up resources after this presentation. It will include the slides describing Julia's presentation on Lohman, and it'll also include the briefing for both of these cases. So we encourage you to take a look at those resources. And thank you to everyone for attending this webinar, and have a great rest of your day. Thank you.
Thanks, Brian.